Good afternoon. I'm Tony Mangan, the Communications Director for the Attorney General's Office. Thanks for being here. The press release is again about another public corruption case the Attorney General will discuss. While the person named has been arrested and indicted, the official indictment has not yet been officially filed in the court system. Just so you know that. When we know that, we'll let you know, but it is in process at this point. If you don't have any other questions, we'll start. Okay, you good?
Not yet.
Okay.
You can step aside.
All right.
Everybody ready? Good afternoon, everyone. Let me start with a positive thing. Today, earlier at noon, I had the opportunity at the state capitol to cast one of 3 electorate votes for South Dakota for president. I'm happy to report that along with what the voters of South Dakota asked us to do, 3 votes were cast for President Trump and 3 votes were cast for Vice President Vance. Also earlier today, proceedings were held, and ultimately a Hughes County grand jury has issued a 26-count felony indictment dealing with public integrity. It is based upon 13 forgery counts. Forgery is a Class 5 felony which carries a 5-year maximum penalty, as well as 13 filing false instrument charges. Those are Class 6 felonies that carry a 2-year ultimate maximum penalty. This case is significant to the Attorney General's office because it involves not just taxpayer dollars, but public health. It evolves around a contract between the Department of Health and the Department of Public Service, where the Department of Public Service renders certain inspection work for state government. In this instance, they were doing inspections for food service for the Department of Health, inspections that our investigation demonstrates did not occur. So there was a period of time, and the indictment period is February 2024 to June 2024, but we picked out 13 instances when inspections had not occurred, that there is an alleged forgery on the business owner, indicating from the defendant that the business owner had signed off on an inspection that had not occurred, and those inspection records were filed and relied upon by state agencies. This case began as a whistleblower case back in October 8th, 2024. It's progressed fairly quickly. Both the Department of Health and the Department of Public Safety have cooperated. And I think, again, this calls out or cries out for what I, as Attorney General, am asking the legislature to do, and that is to provide mandatory reporting of all felonies to the Attorney General, dealing with public corruption, whistleblower protections, which we have in place here beyond just what I, as Attorney General, had received in Senate Bill 27, a level of accountability, and a stronger auditing process. The defendant is Renee Strong with the 26 felony indictment. She's from Springfield. She's presumed innocent. She was arrested earlier today, and bond has been set at $1,000 cash. And I certainly would answer any further questions that you may have regarding the case or what is happening at the AG's office.
This brings the number to 4, the cases that DCI is investigating in peer and state government?
At this time, there have been 4 charges There are additional investigations occurring that I've not spoken to, and it would not be appropriate at this time.
You had said before that one investigation led to another, and then another led to another. Is that what's going on here?
To a degree, I said it was a whistleblower. It was a whistleblower that contacted the Attorney General's Consumer Division. I think that a light has been shed upon this. I've talked about it earlier where we in state government have 14,071 employees. If you think of that as a corporation, there's some illegal activity that is occurring. And I think bringing charges like this, 4 different occasions, has let state employees know that they have an Attorney General that will listen and that will act upon this criminal activity, which is what we're doing, not just with criminal charges, but propose legislation that will better protect the whistleblower, add additional accountability for the public and the media, and a stronger accounting system so that these are caught earlier on than a whistleblower.
Austin Goss, the Dakota Scout. Can you speak at all maybe to what the motive was to do this, or what the incentive was to forge these, falsify these?
It would, of course, that is something that may come out further at trial, but generally speaking, when these inspections occur, an employee is paid either an hourly wage or by the number of inspections. And so there's a financial gain to do the inspections that the employee would be paid for if the inspections didn't happen. And again, the allegations, she's presumed innocent, are that the inspection didn't happen, that there was a forgery of the business owner's name, and the document was falsely filed with the Department of Health and relied upon by the Department of Health.
So there were 26 cases of this. Do you have any idea of what the monetary impact was to taxpayers or the state?
So we chose to bring charges in that time frame that I mentioned, February 2024 to June 2024. There were other instances, and we've not put a dollar value on that. At some point, there may come more information on this if there is a filing under 404B or res gesti that would indicate the other instances. But we felt, not unlike a drug case, it's not appropriate for a prosecutor to stack charges. 26 felony charges, but I think if you do the math, she's looking at 91 years. In my mind, that is sufficient for the alleged conduct.
Were any business owners involved in any wrongdoing?
They were involved, but not in wrongdoing. 5 specifically cooperated. I can't give you the name of those business owners. I would suggest that they range from wherever food services, whether it be bars, restaurants, country clubs, and then mobile food services. They were very cooperative, pointing out that those inspections had not occurred, that they were not their signatures.
It says here that she was employed by the Department of Public Safety, working for the Department of Health. Is that common for that line of work when you're doing food inspection?
I can't really opine beyond this case, but I would say within the Department of Public Safety, they have a unit that trains to do various inspections. As part of that, areas of state government, not the Attorney General's office, but other areas of state government rely upon that service. So in this instance, the Department of Health had contracted with the Department of Public Safety with that expertise, so she was doing the inspections per the contract for the Department of Health as the Department of Public Safety employee. And again, both the Department of Health and the Department of Public Safety were cooperative once the whistleblower had identified the concern.
How long has this person been working in this position?
In this position, I understand about a year. The individual, I believe, has worked for other areas of state government, but in this position, approximately a year.
How long overall do you know in state government?
That wouldn't have been something we looked at in the investigation.
You mentioned your proposal for stronger whistleblower, mandatory whistleblower, and stronger auditing. You've talked about that before. What's been the reaction to that?
I would suggest mandatory reporting of felonies to the Attorney General, whistleblower protections, and transparency has been overwhelmingly positive. The pillar with respect to the stronger audit service has been less so. Part of it is to appreciate the function of an elected auditor, the function of BFM on behalf of the government and state government and the governor, the auditor general that works with the legislature, and then to some degree the internal control board. You'll see a proposal from me that tries to add transparency for an elected auditor, and that tries to give additional powers to the internal control board through a rulemaking authority. We have that in some areas of government, like the Law Enforcement Training Commission that's housed within the Attorney General. We have separate rulemaking authority that we have to go to the legislature for. So I think it works well. It's worked well for us. But that's what I envision. I would tell you that the legislation that I have drafted has gone to LRC for final editing, and then it'll go to the chairs of the respective, typically it's judiciary, some of this might be in state affairs, and then it'll be made public, hopefully well in advance of session.
What is her anticipated initial court appearance date?
You know, typically they're within a day or two. Again, because bond has been set, that, you know, that's a function of when the court's available and whether or not there'll be a need to adjust bond.
26 forgery-related charges, would that be 26 different businesses?
Not necessarily.
Okay.
Some of the businesses were the same. And part of that is, under state law, there is required to be 2 food inspections a year. It's not federal, it's state law. So some of them, if you look at the time frame, could encompass the same one twice. And does in fact do that.
Was Strong in a particular region in her job, or was this in a particular area of the state? Whose businesses?
She's from Springfield, generally speaking, in that. If you look at the different businesses, there appears to be a pattern, but again, I'm not part of making the contract between the Department of Health and Department of Public Safety, and I don't want to misspeak to the facts. I will confirm she's from Springfield, and beyond that, that's more of a question for them.
So the forged inspections, did those businesses not get inspected then? Is that right?
That would be fair. That's why I believe it's both a taxpayer issue and a public health issue. I would indicate that I don't have any evidence through this time frame of any concerns to the public, but that is a fair assessment that the law requiring 2 inspections may not have occurred, but it's not the business owner's fault. And in some instances, the businesses weren't open when the forgeries happened, given the time of year or the restaurant scheduling. But at that level, no, there would have been no inspections.
So that's a lot of businesses to not, they're restaurant owners, food service, did it not come up and nobody said, I haven't been inspected? Or did they get inspections otherwise? Were there like duplicate inspections, you know what I mean?
There were not duplicative inspections. I'm not aware of any duplicative
But
inspections.
no business owner said, you know, I haven't had an inspection for.
I think in fairness, I would say this. These businesses were exceptionally cooperative with law enforcement. I say that because sometimes if you're not cooperative, we have to seek additional prosecution tools that we didn't have to seek here. They opened up their books, they were cooperative. I think you're busy enough in some of the food industry that maybe you didn't notice they hadn't come by, and I don't fault them for that. That's the state's responsibility, and that responsibility wasn't met.
So she was just sloughing off. She wasn't doing inspections. She was like hanging out somewhere, not doing her job. Is that basically what we're saying?
I'm not her employer, so what I would say is she was not completing the inspection she was paid for, in my opinion.
Did she get paid as a contract? On the contract, she got paid per inspection or she got paid a salary?
They do a little bit. It's per inspection and hourly.
Okay, so she was benefiting financially by forging the documents, not.
Yeah. Yes, which is why it's a taxpayer issue and a public health issue.
Were these businesses notified at all that she was gonna come, or were they just eventually aware that no one had come, and then it came back to the fact that she was the one that didn't come to their businesses?
The answer is some were aware, some weren't.
The whistleblower is outside of the restaurant industry or within the restaurant?
Whistleblower would be a state employee. And in my position as Attorney General, protected by the Attorney General's previous Senate Bill 27, and because I brought charges, witness tampering. So their protections do exist for this employee, and that's important to me that, as I mentioned, on these whistleblowers, there has to be a situation where if something bad is happening, that the whistleblower believes they can trust the Attorney General, and they can trust that the Attorney General will do something, and I think today we're demonstrating that.
Can you speak to broadly what the red flag was on or around October 8th that maybe sort of gave rise to, hey, I don't think these inspections are happening?
All I can say is that we were contacted, we being the Attorney General's Consumer Division, and we received a tip.
You said that was October 8th?
October 8th, the tip may have come in October 7th. We acted on it October 8th.
I'm sorry, you said the words witness tampering. What was that in regards?
So I would indicate that there are protections. So if somebody were to come forward and be a whistleblower, I've talked about the legislative package that includes strengthening those protections. But what I pointed out is, with respect to that whistleblower that came forth in this case, they would be protected by, number one, the Attorney General's previous Senate Bill 27, as well as because there's a case brought, they're considered a witness. So if some adverse conduct, which I don't believe would ever happen, like I said, Department of Health and Department of Public Safety have been cooperative, but they would be protected under the witness tampering statutes. In other words, you can't take adverse action against a state's witness, or that triggers criminal penalties.
Is there any significance to this being 13 Class 5 and 13 Class 6? That these are all for these are 13 businesses that were affected, or 13 instances where she didn't do work or opt to?
I think it comes down to prosecutorial discretion. We picked a time frame. We picked the most straightforward counts where we were able to, through the businesses, make sure we felt strongly about what our position was in charging. Again, I've indicated there were more instances that are not contained in these charges. They may become part of motion practice on a 404B res gesti motion. But again, I feel that a 26 felony count indictment, the legislature sets the Class 5 and the Class 6 penalties, but that's 91 years, and that's sufficient. That's more than sufficient.
Can your office say about how long you think this is going on then, if these aren't all encapsulated in, or if that's not all encapsulated in these charges?
She worked there for about a year or so.
You went to, Tom asked you about if one report leads to another, and now we're up to 4. But it does seem like it's a lot. So my question is, was there this sort of lax culture before, and now you're clamping down, so people are coming forward? Or is just this happen that we all of a sudden have this flare of public corruption?
You know, I would say this. I think, you know, every case is based on different facts and circumstances. I mean, it takes somebody with courage to be a whistleblower. It takes the governor putting forth a new accounting system to catch something. So there are a variety of explanations, but I go back to part of it is, I think people are seeing that they'll be heard. Whether it's if they report it to their boss or directly to the Attorney General, something will be done about it. It's being done about it. You know, this particular one doesn't date back many years. I'm not talking about the management of it or the circumstances behind the contract. Some of these, I mean, they're going back to the year 2010. And so there's been a level of things happening, and I think the publicity of this has shed light on it, and I think there's a stronger comfort level for witnesses to come forward. And they are coming forward.
What's the tip line again? May as well just shoot that out.
Well, this one came to the Consumer Division. It's food related. 1-800-300-1986 is the Consumer Division's phone number. I've called it a few times.
I'm going to ask a similar vein to Lally's question. I mean, this is the 4th case this year. there's a string of cases. Is there a through line to this? Do you think that this is emblematic of a problem of corruption in state government in South Dakota?
You know, I go back to my statement. There are 14,071 state employees. It's a large business. Any corporate headquarters with 14,071 employees are going to have some problems. There clearly are some problems in state government where the Attorney General wouldn't have brought 4 different charging documents. That problem, I believe, is being addressed. I would point out, as Attorney General, I previously asked for it to be addressed, and part of that package passed, part of it didn't. You're the press, you can go back and look at what happened to that package. Senate Bill 27 in part passed. I've got a proposed solution, but it's up to the legislature to decide, is this a problem, and is the Attorney General's solution a fix to the problem? Perhaps they might look at some other opportunities, but those 4 pillars that I've talked about today, I believe would be a very good start, and I want to begin that conversation with the legislature.
You know, in one sense, you always start over in any legislature, but there's a lot of turnover in the legislature. Do you feel like you're bringing this back into a different culture that might be more receptive to the plan?
Yes, and over time, there's additional charges that have been brought to justify it. So, I mean, I think to answer that, it's in part yes, but in part, because of what has been happening, gives further justification to look at mandatory reporting to the Attorney General, to give those whistleblowers more protection, to shed more light on the process through transparency. And I point out to you, most of the transparency I put on the Attorney General, I put on me. And so there shouldn't be pushback on that. If I'm willing to tell the public the Attorney General received 18 mandatory reports and this is what we did with them, I wouldn't know why the legislature wouldn't agree to that. Other questions?
Sorry, I might have missed it. How much is her bond?
$1,000 cash bond.
Okay.
Where's she being held at?
Law enforcement get mad at me if I tell you that. Not able to say those things.
I'll find out.
I know you will. Not from me. You guys are good at what you do, but you're not getting it from me. And the reason for that is, you know, we would hate if there was an escape or something, that I may be something that I said I was part of it. No suggestion that's what's happening, but we just typically don't and to avoid other problems.
Just one more question from me. You know, it sounds like you're wanting to put together this plan to increase transparency, as you said, improve transparency, and tackle these cases. As far as what we're dealing with right now, just in your opinion, you know, we're dealing with these cases that the oversight, you know, where does the buck stop in terms of oversight? I know there's plans to, you know, bring in the Bison 605 or the Drive 605 in the Bison project, but, you know, these employees also had bosses, they had department secretaries, you know, they had Governor Nome looking over the executive branch. Who's responsible for this? Other than the employees who obviously made this incorrect decisions, allegedly, where does the buck stop?
I mean, my responsibility is if you commit a crime, I hold you accountable for that crime, which is what I'm doing, and that's where that stops. I mean, those other questions, you'd have to ask those managers and those executives. If it were happening at the Attorney General's office, I would answer it, but my employees don't have time to do that.
Anything else? Okay.
Thank you, everyone.
Call if you have questions.